Okay, so this is a presentation or excerpts from a presentation that folks from our office will go out and give to the districts. If you've got engineers that need help preparing for testimony, if you've got a project coming, we've given it to groups of appraisers, other expert witnesses, land planners. We've given it to groups at right-of-way conferences where we're dealing with right-of-way agents and the acquisition providers. So if you've got a project coming and you fall into one of those categories and you want to have a pre-kickoff meeting to talk about what we're going to be doing and things that you can do to make the process go easier from our side, from our vantage point, please let me know. We travel a lot. We are the transportation division, and we can send somebody out to do a presentation tailored to your group to really, it's in our interest because we're helping us, when it comes to us in litigation, it helps us do a better job. So the topic, as I've laid out on the slide, covers a lot of ground, and we won't get into all of that in the 20 minutes that we have here today. But one thing that I am consistently surprised at when dealing especially with the engineers is just the lack of knowledge about the process as it goes forward. And so we really begin with an introductory presentation on this is what's going to happen. This is how we're going. We always joke in our office that TxDOT stops paying attention once they have possession, because that's what the engineers care about. They get possession, they get to go build their project, and they're not worried about it. And so trying to wrangle someone up to testify at a deposition and be a trial witness can be difficult. And so we want to just spread the knowledge that, yeah, it doesn't stop with possession from our side. That's really where our work just begins. And so we cover a lot of this ground, again, mostly focusing on engineers and talking about what kind of testimony you're likely to give at the special commissioner's hearing, what you're going to be doing at trial, what's going to go on between now at project kickoff and the end of the day when we actually finally conclude everything, sometimes long after the project has been built. So, and then we always end with common problem areas where we see the most issues that arise that cause us real difficulties in litigation. That's in depositions and the emails. And so we have done this presentation. I know a number of times we did it with a number of Don's projects in Dallas, even in El Paso. Laura and I put it on for her engineers in Fort Worth before the I-30 360 kickoff. And so, again, I encourage you, if you are interested in learning more about this stuff, obviously ask questions today, but you can reach out to me. Kyle knows how to get in touch with me, and my contact details will be up when we're done. But at the special commissioner's hearing for engineers, will almost always be called at a special commissioner's hearing, and we will always talk about first of all, introduction of yourself as an engineer, and then tell us about the project, what's going on, why we're doing it. Spoiler alert, we're always going to talk about safety. One of the messages that we try to convey from the very beginning, I always tell them Jesus loves the little children. We're trying to make the road safe for those little children to be out there driving down the roadway, riding in their parents' cars or when they get their license. So we focus on safety, and we will talk about all of the safety impacts that our project will have. And then we always deal with the specific parcel. What's going on this parcel? And so hearing the talk earlier about having the engineers go and drive the project beforehand, or having the right-of-way folks, I encourage the engineers to make that drive also. We've had engineers, testifying or meeting with us ahead of time, saying that when they look at the map that comes out, the buildings, or in engineer speak, the vertical improvements, they don't know what they are. They're lines on the paper. They're either a rectangle or a square or a circle or whatever, and it may be a canopy, it may be a house, it may be a 17-story office building. And without knowing what that's going to be, how that's going to impact each parcel, we have a real problem. And so I'm glad to hear that that's becoming a more common practice of going out and driving the project, and I encourage that for sure. But we'll definitely offer testimony about that. Next, we're going to talk about the jury trial, the second phase of the acquisition process. This is the final say and valuation. Engineers often don't know that we go that far and are shocked and surprised when they get there. We have a situation right now in a case in Fort Worth where, as often the case, the engineer has been promoted out of his position. He was named as a witness. He's been identified as the trial witness. He's been deposed, and we're going to trial. So we call him up and say, hey, we need to meet out your trial testimony. And the response is, oh, that's not me anymore. You got to go to this new guy. Unfortunately, that doesn't work for us. You're still the guy if you got named and deposed. And so that's a common occurrence in TxDOT, that the engineers move a lot, obviously, and so we have to track those folks down. So we want to make engineers certainly aware of that. And the right-of-way folks often will be promoted or moved on. And we call, I know there's a lot of folks here in the room that used to be in TxDOT and have moved on to outside work. They still get called back to testify on behalf of TxDOT because they were the person involved at the time as the right-of-way agent or as the supervisor or whatever. So that's something we obviously want folks to always be aware of. All right. When it comes down to testimony, one of the things we'll focus on is preparing for your testimony. And one of the best ideas I've seen in helping witnesses prepare, and this was one of the ideas that came up on the SPD projects, I think it was first done, at least in my experience, on the NTE project in Tarrant County, was having a notebook prepared for each parcel for testimony. And so it was the parcel map, the right-of-way, construction plans for that area, traffic counts, all the documents that you might need that you're going to get asked questions about as a witness in that case. Those were organized so you weren't fumbling through, you knew exactly where to look. Each tab was the same in each notebook, so you knew tab 1 was the right-of-way map. Tab 2 was traffic counts. Tab 3 was the construction plan or whatever, or however that order was, so you knew. That's one of the best things that we encourage the witnesses to do. Whatever you're going to have it all prepared, ready to go, and keep it consistent. And always practice, practice, practice. We will prepare with you before a deposition, before a commissioner's hearing, before a trial, but there's a lot of practice you can do on your own as well. And so we'll go through sample questions. What we're going to ask you for sure, we will walk you through, and what we expect the other side will ask you. Not always a full-on fake cross-examination by one of us, but things to be prepared for. Body language is really important, and I just learned earlier this month back at UT at a seminar, they were doing witness surveys, witness studies, and presenting the outcomes of that, is that witnesses give more credibility to people who talk leaning forward. That's why I'm leaning forward here today. I have changed the way that I prepare. I'm usually much more, chill, like back, let's talk, let's good. But juries don't like that. They don't take they don't give as much credibility to testimony that comes from somebody who is relaxed back in the chair. I always like to be relaxed back because I feel better, I feel more comfortable and more confident. But now I have to lean forward. And so we'll talk about things like that, body language, tone of voice. And something I'll always recommend for both lawyers and for witnesses that are starting out is videotaping yourself. You have an idea of the kind of questions you're going to be asked. You can practice answers, and you'll see that, body language tics, things that you might do. If you're constantly pushing your glasses up, it's a nervous tic, you're not aware of it, but your hand's in front of your face. You're blocking your mouth from the words coming out, and so that's something we would work on. So I always recommend videotaping yourself if you can. Testimony resources is another thing that came from the SPD presentation that we've adopted wholesale, is making sure that all of those resources are available. If you're called to testify on behalf of TxDOT, you're the face of the state. You're going to be you're the guy or you're the gal that's going to be there to speak for all of TxDOT, and you're going to be expected to know everything about all of TxDOT. And there'll be objections that we can make, it's really outside the scope of this witness, but there's things that you're going to need to know. The design manuals, the right-of-way manual, access guidelines, all of that stuff that is TxDOT generic, applies to the whole agency. There'll be specific things out of that we'll want you to be aware of, and so we'll want you to have access to those resources. The federal and state regulations, minute orders, project parcel file, you can read the slide, but we will go over those materials with you to make sure that we're all on the same page, especially on things like access, driveway spacing. What kind of driveways can we put in here and how far apart do they have to be? What's the number? All of those type of specific engineering questions we'll want you to be ready to answer. All right, first typo of the day, apologies. All my proofreading didn't catch do this. Do not do this. If anyone has heard me speak before or dealt with me at all, you'll know why this is wrong. This is showing the TxDOT acquisition of a small strip of frontage, and when we color it in red, it looks like we have cut the land off and it's bleeding to death on the table there. We don't use red. It's a terrible, terrible color for TxDOT. I recommend doing something like this, nice and lovely green and yellow outlines, especially with this one, because we know that's an acquisition of about 10 to 20 feet in width. What color is that going to be when we're done working? It's got to be green, right? That's the safety buffer space where we're going to have the TxDOT furniture and signage and whatever else. That's a word I picked up in El Paso, TxDOT furniture. If it's going to be green in real life, let's make it green on our exhibit so we know that's not going to be pavement. That's going to be where the beautiful landscaping is going to be put back, or the sidewalks. So making the exhibits, preparing the exhibits is something engineers generally will help out with. Usually will provide us wholesale, and we'll adopt them and use them. So color schemes matter, and we'll talk about that as we go through. The most important testimony you'll give as an engineer that we'll offer, and right-of-way agents will also be involved in this testimony, is when the state's right to condemn is being challenged. And this is something that's becoming more and more frequent. We had a couple of enterprising lawyers up in Dallas that have made some hay with these kinds of challenges, and we have defended them successfully on the LBJ project, on the NTE project, and we're facing one now, unbelievably, on a project in Belton that's just a traditional, highway department building a highway. So we're seeing them more and more, and it's the situation where the landowner says, we don't think you have the right to acquire our property through condemnation because it's either not a public use or our parcel isn't necessary for this project. And so the engineers will testify specifically to this, and the right-of-way agents will be required to testify that we have met all the steps and met all of our burdens, checked off all the boxes that the property code requires us to check. And so this testimony can be really damaging if it's not good. And so we will work very, very hard on getting this right. But even with all of our hard work, mistakes are made. This next slide is from a trial a testimony from a trial that I had in Dallas with Chris Gunter, with Laura's husband, and we were acquiring parcel for expansion of 35. Actually, it was part of the LBJ project, but it was on the 35 side. And we were acquiring northern edge of the property and the eastern edge because we were adding in continuous frontage roads and ramps. And the landowner's lawyer asked, why is the state taking this portion of land along the east side, not just the north side, where the road was actually being widened? And the engineer's response was, I'm not sure we'll use all of that land. We may not need it. And that's a terrible answer. That is the worst possible answer. And so, and this is an engineer that had testified on all the commissioners' hearings, great guy, we'd worked a lot together. He knew what the answer was, because for safety reasons, we're acquiring extra land and putting in continuous frontage roads and extra buffer space along the side and adding in a ramp there so cars can safely enter and exit the freeway. That's why we're acquiring additional land. That's not what he said at trial. And so we can correct that at the commissioners' hearing. Commissioners' hearings are very informal. We'll talk about that. We can correct that at the trial. At the deposition. We can't correct that at trial. That's a real problem for us at trial. So we'll talk about that. Design discretion is not something that you tend to have a lot of concerns about, but it can cause us problems. Your design discretion is not going to be questioned. The way we design the road, safe, all that is good, but there are questions that we may have. And this is one that is from a trial in Granbury where we were replacing a 48-inch 10-horn culvert with this, and it looks terrible. It looks like we're going to flood this property. And if you know anything about hydrology, you know that's not the way water works, that just because you build a bigger bridge means more water is going to flow under it. But that's not what jurors see. And so we'll talk about that and whether we need that. And so we have ways to answer those questions, but the more we are involved, the better off we're going to be. In depositions, we do much more deposition prep when we're actually preparing for one, but as part of the presentation, we will talk about generally what the rules are, telling the truth, not volunteering answers. Don't guess. Make sure you understand the question and stop once you've answered it, because nothing good happens after stop. We'll always focus on that. And what we want to avoid is having questions that undermine our position or answers that undermine our position. And so you have to support your answers with your opinions, your conclusions, with our data. And so we had an answer in a deposition once. How did you conclude that empirically? It was just a subjective opinion. Hey, we don't want that. That's a problem. That's a real problem for us because that testimony gets challenged quite frequently if we don't have any underlying data to support it. And always, emails are a problem. And we will focus a lot of time on this, talking with both right-of-way staff, the outsource providers, and with the engineers themselves, because expert emails are always discoverable. So any communications with our expert witnesses, and engineers are, by definition, expert witnesses, generally get produced. And so if there are emails pinging around the office talking about a project or a parcel or how much I hate this landowner or this landowner's attorney's a real a-hole or whatever, that stuff comes out. So we always have to be mindful when we're sending emails. We don't want to include personal conversations. We don't want to have personal attacks. We want to keep them as cut and dried as possible. And we certainly don't want emails like the one I'm about to show you, which is where I always end my presentations. And it was on a parcel that TxDOT had initially offered $400,000 on, and the landowners demanded $40 million in response. It was a 17-story office building that the state was acquiring property. It came within about 7 feet of the building, and they said, you got to knock it down and start over. And the question came during the course of the litigation as we got closer and closer in to trial of, do we know how this building is actually supported? The underground shafts that support it, are they up and down or are they slanted? Because if they're slanted, they're going to go further outside of the 7 feet into our new right-of-way, and that's going to be a problem for us. And instead of saying, do we know this question because it could be a problem, the engineer in charge sent this email, which was, if that's the case and the pier piling or shafts are on our right-of-way and the mediation hasn't been accounted for, then the price of poker just went up. And that's devastating to us and the jury. If the courtroom could have a screen this big and the landowners council could blow that up this big, they would have. If I was landowner's lawyer, I would have had it skywritten above the courthouse so the jury saw it as they were walking in. Because you see, the states, this isn't anything to the state, it's just a game. They're worried about their costs. This is just a game of poker to them. They don't care about us. They don't care about our clients. And so we want to always be mindful about keeping stuff like that out of the landowner. We don't want to give them the bullets they're going to use to shoot us at trial. And so I will conclude that here. I'll take any questions, but that's my contact information. If you have any questions, call me, email me. You can reach me through Kyle. We're more than willing to come out and speak to your groups of engineers, your right-of-way division folks, whatever. Anybody who wants to come and hear more about mistakes that have been made in the past so we don't repeat them, we are more than willing to come out there and do that. So, and I'll take any questions now if we have time. I believe we have a few minutes.
Yeah, we probably have time for about one question. One or two questions. Right there. Yes, sir.
Yeah, I have a question. You mentioned access, and why do we need to know the access to the driveway during this process? It should be based on the plat process.
So let me repeat the question. The question was, why do we need to know about access and where driveways are going to be during litigation?
Because access is the single most important thing that especially commercial properties deal with. They can't get compensated for visibility. They can't get compensated for a lot of things by law, but access is one they can get compensated for, and there's now special rules that determine, that say you can get compensated more for access now than you could, say, 6 years ago. And so having lawyers involved up front, we can talk about that and identify parcels that will have potential access issues. We had a question on Laura's project in Fort Worth and Arlington where they were looking at possibly doing a shared driveway between two parcels. Well, we can't condemn a driveway for this parcel. We can't condemn land over here to help this parcel and vice versa, because that's not a public use. That's a specific driveway for these two private landowners. So we had to step in and say, yeah, we can't do that. I mean, Laura had brought it up, and we were just there saying, yeah, she's right. Well, then the question became, okay, we need to shut down some driveways so we can maintain access management. How are we going to do that? Well, one property was a multi-million-dollar apartment building that had 300 units. One was a restaurant. Okay, well, smart call is let's shut down the driveways to the restaurant. We pay them whole value, and we save the apartment complex. That's a economic decision that we're going to look at for litigation purposes as well. In the end, I think we're actually able to save both by squeezing some, spaces down and being able to provide access to both. And both acquisitions went off without a hitch. I don't even think we had commissioners' hearings on one of them. One of them, I think we had a commissioners' hearing and it got settled shortly thereafter. So being involved in knowing what the access rights are going to look like as early as possible is really, really important, because it's the one thing that landowners can certainly seize onto. They know they can get compensated for.
All right. Thank you, Clint. Appreciate
you.
your time. Appreciate y'all. If y'all have any more questions,